Hi everyone, and welcome to the Construction Mediation Q&A. My name is Stuart Lawrence, and I'm the founder of Mediator Locator. I'm a barrister, accredited mediator, and adjudicator with over 30 years of experience in dispute resolution, and construction is one of my specialist areas. For background, Mediator Locator is a national mediation service with panels of expert lawyer mediators across the UK. We currently partner with 16 prestigious law firms, and all of our 30 specialist lawyer mediators work within those partner law firms. Mediation is all we do, and when it comes to construction disputes, our mission is to match cases with mediators who really understand the nature of the sector. Construction disputes are often more complex and costly, with tight deadlines, cash flow pressures, and high stakes relationships, where keeping the project moving can be just as important as resolving the issues. And in our view, mediation offers a smarter way forward. So today we're having a construction mediation Q&A to explore why mediation should play a much bigger role in resolving construction disputes. And I'm delighted to be joined by two fellow construction specialists from our panel, Rachel Murray-Smith of Sharp Pritchard and James Johnson of Burnett. So starting with you, Rachel, maybe you can introduce yourself and say a little bit about who you are and your background.
Sure. Hi, everybody. I'm Rachel Murray-Smith, as Stuart's just mentioned. I'm a partner at Sharp Pritchard. I started life as an in-house lawyer at a local authority and moved across to Sharp Pritchard more years ago than I would care to reference now. Having started my life as a procurement and contracts lawyer and quickly started to focus on construction contracts and haven't really ever looked back. And sort of working in that industry came to mediation in terms of qualifying as a mediator a few years ago, recognising how impactful it can be as a route to resolving disputes in what is probably well known to be a fairly litigious industry. So I think that probably sums me up.
Lovely, thanks, Rachel. And James, if you could do the same.
Yeah, morning everybody. Yeah, my name is James Johnston. I'm a partner at Burnett Solicitors in the north of England, Cumbria and Newcastle upon Tyne. I'm a litigation solicitor. I've been a litigation solicitor now, probably over 15 years. My own particular expertise is in commercial and construction dispute resolution, and I've been accredited as a mediator with CEDA since 2020, so coming up 5 years now. And it's an area of work that mediation is an area that I just think is a superb way of resolving the issues that are pretty much commonplace in commerce.
Great, thanks, James. I appreciate that. And I'm going to start with questions. So, Rachel, if I can start with you first. If you had to sum up in a sentence, why does mediation suit construction disputes so well?
So this is a really quick, easy one, and I think you've already made reference to it in your intro, Stuart, which is that we all know the phrase that cash flow is king in the construction industry, and mediation provides a route to resolve disputes quickly and also very cost effectively. So I think that's a nice, easy one to start with.
Excellent. I wanted to give you a soft one to warm us all up. Okay, James, moving on to you. When you walk into a construction mediation, what's different about the dynamic, would you say, as compared to, say, an arbitration or an adjudication?
I think in my experience that there is, generally speaking, an attitude that the parties are there to get something done. It's a process that both are there willingly to engage in, with a shared goal of trying to resolve their dispute. And I think that is just by its very nature different, and it creates a different atmosphere, perhaps a more collaborative atmosphere, perhaps a more purposeful atmosphere than one would experience in a contentious setting such as an arbitration or an adjudication.
Yeah, I mean, I think, just picking up on that, I think people probably maybe more familiar with adjudication in construction, but it's determinative, as is arbitration. I mean, in terms of cost of adjudication as compared to mediation, what do you see? I mean, from my experience, having done a number of adjudications, I think originally it set out to be more of a sort of party type process, but it's become increasingly legalistic and expensive. Is that your experience as well?
It is, yes. I mean, the last time I did an adjudication as a advisor was just earlier this year, and it went the whole hog in terms of pleadings. It was quite a complicated, factually complicated case, but it went the whole hog, full round of rejoinders and surrejoinders, and it just became it was an incredibly expensive case. And then, of course, there's the fee of the adjudicator to pay as well for the party that's unsuccessful in that.
Yeah.
And I think you're right. It started out very much as it intended to be a short, sharp way of keeping construction projects working, and sometimes that is still the case. But it, in my experience, has undoubtedly become a much more contentious affair than I think it was originally intended to be.
Yeah, and I think, you know, being both of those processes being determinative by contrast with mediation,
Yeah.
you know, the parties get to choose, and you know, you can be more creative. So
Yeah.
no, that's interesting that your view accords with mine. I think that's something that a lot of people say. Coming back to you, Rachel, what's in your view the biggest myth about construction mediation? Can you come up with something that covers that?
So yeah, I think from my experience, the biggest myth is that it's not an effective means of resolving a dispute, and that the parties feel that they'll inevitably end up in an adjudication, arbitration, or litigation, notwithstanding a mediation exercise. And you know, the statistics and my own personal experience just don't sort of support that view. You know, it is an extremely effective method of resolving the disputes, and of course through this discussion we're already touching on some of the reasons why that is. And what I've also found, and probably is something less talked about in my experience, is that you can have something, as James just said, a very complex issue or a multifaceted sort of multi issued dispute where it's not just one thing, and actually through a mediation you can at least settle some of that, and that can be a really positive step to moving forward. So it's not always about getting it all wrapped up, but actually you've moved 80% of that forward, which is really significant in the circumstances. So I think that would be my sort of biggest myth.
Yeah, no, I mean, I agree. I think the statistics show something in the order of 90% of cases referred to mediation actually settle. I think something like 80% settle on the day, and then the remaining 10% in that statistic over the coming weeks. But as you rightly say, even if you don't resolve the issues completely, you narrow them significantly. And that's quite a nice segue into the next question, which to you, Rachel, projects live and die on relationships.
Yeah.
How does mediation help keep ties intact when the contract's under strain?
So I suppose the thing about mediation is that I think it recognises that people and personalities have a significant part to play in any dispute, and a mediator can really help focus on outcomes and move away from some of those personal or entrenched positions in a way that I don't personally feel is always possible in a formal dispute resolution process or litigation. And you know, for want of a better phrase, it takes the heat out of that, and enables parties to move beyond some of those things. And I really liked some of the commentary in the recent DKH Retail Limited case, where the judge said that mediation would be able to focus on possible solutions rather than raking over historical grievances. There's some other really good parts of that judgment as well for those of us who work in and around mediation in terms of the strengths of it. So I think it can be also very, very effective in resetting a contractual relationship. And I see this a lot. We work almost exclusively for the public sector, and so we have long-term contracting relationships where they've just slightly gone off the rails, as it were. And actually mediation partway through a long-term contract can be extremely helpful in sort of resetting, rebaselining that contractual and personal relationship between the parties to enable a successful ongoing relationship. And I think that's particularly important in the context of the fact that for us and our clients, a lot of those contracts relate to frontline services, and so those more sort of draconian dispute resolution routes or termination just really aren't suited to what they want to achieve, which is kind of ongoing and seamless service delivery for their residents. So I think it's a good way, like I say, of taking some of the, in a good mediation, some of that personality out of the dispute and focusing on outcomes.
Yeah, yeah. And in relation to sort of arbitration, adjudication, litigation, have you ever had clients who've gone down those routes who've actually ended up still talking to each other, or is it always irreparable breakdown? Because in my experience, it tends to be that case.
I think it's quite rare, isn't it?
Yeah.
Because you're pitted against each other. You've got
absolutely.
to be right. There is no middle ground. You know, so whereas mediation, as we know, and as you've said, it's a much more creative form of dispute resolution, and you can bring other things into play in a way that makes people feel like they haven't lost out of the process, which enables then that relationship to continue in a way that I don't often see when you've had to go through another form of dispute resolution.
And I think that's probably particularly relevant in construction, because obviously, you know, you're working with subcontractors, you're working with main contractors and developers and main clients, you know, preserving those relationships, having a good subcontractor working for you, maintaining that relationship even when the project goes wrong, because they so often do. Preserving that relationship and building on that, having those conversations can make such a difference. And I think from my point of view, that's where there's a unique feature of mediation, in that you can preserve relationships, whereas in no other dispute resolution process that can happen. So no, that's great. Thank you very much. James, coming to you. Mediation isn't just about splitting the difference. I think Rachel alluded to the myths of how effective it is. How does mediation allow for creative project-focused solutions rather than other process, sort of something we've just touched upon? But in your experience, what would you say to that?
I think the kind of the structure of it, the framework of it, is fundamental to this. So, I mean, the fact that it's confidential is very liberating, actually, to the participants, and it's entirely without prejudice. So, I mean, that very framework allows for really free-flowing, creative dialogue, creative thinking. It allows issues to be brought in that perhaps aren't or couldn't be dealt with elsewhere, that might be relevant, whether they are the possibility of an ongoing relationship, future work, you know, various factors that the parties can bring into their dialogue in that sort of safe space of knowing that those discussions can't go elsewhere, whether that's in the confidential room that one team has with their mediator, or whether it's under the umbrella of confidentiality as a whole, allowing the parties really the freedom to exchange dialogue that they probably, certainly in my experience, would never do at any other time or any other juncture. Certainly would never do in contentious proceedings of any nature. So I think it just allows that, really, you know, to use that phrase, that safe space, protected by confidentiality, protected by without prejudice privilege, protected by the agreement that everybody signs up to, so you're all in the same boat. And like I said at the start, I think it's one of the really relevant things in this is the fact that the parties are there willingly. You know, they are there because they have a shared purpose, and that shared purpose, even if they've got nothing else in common because of the nature of their disputes, surely the one thing they've got in common on that day and the discussions leading up to it is that they want to try to resolve their disputes. So that actually, when the penny drops that the other side also want to try to resolve this, I think that can allow for, you know, real progress is then made relatively quickly, actually, certainly in my experience. So I think it's that concept of that safe space. It's protected entirely from anything else.
And just picking up on one point about sort of splitting the difference, I know people have said to me in the past, "Oh, mediation, you just sort of cut it down the middle." I mean, I've equally heard that comment made in relation to adjudication. Adjudicators just go down the middle. You know, I don't think that's fair in either jurisdiction, adjudication or mediation, because I think, you know, there's a reality testing in mediation and there's a critical analysis in adjudication, where people look at overinflated claims, they look at the evidence, and you have to inevitably compromise in every form of dispute resolution. But I agree with you. I think in a safe space, you know, you get that ability to compromise in an intelligent and sophisticated way and hopefully reach solutions. No, that's great. Thank you. Just quick fire one for you, James. In construction mediation, in person or online, or both, or hybrid?
Yeah, both. I think I think hybrid's always a bit tricky, to be honest, where you've got some people in a room and some people on screens. That can work depending on the number of participants and parties. I think either. I think if you're going to do it in person, everybody ought to be in person. If you're going to do it online, everybody ought to be online. That's generally a good rule of thumb as far as I can see. Both can be very successful.
Yeah, I mean, I think you're right. I think, you know, it depends on the circumstances. I mean, we're doing some training on neurodiversity, as you guys are aware, and I think people who may have neurodiversity issues might find online very valuable, because it gives them this security and safe space, as you mentioned, in other contexts, to allow that. But equally, I think, you know, when people turn up in person, there's perhaps a greater deal of investment. And the probability of settling may be higher, but then you've got the additional travel costs. So it is a bit of a sort of provocative question, because it just kind of depends, doesn't it?
Yeah, it does. Yeah.
Okay. Moving back to you, Rachel, we talked a little bit about confidentiality, and James mentioned it, and, you know, sometimes it's overlooked. In construction, where reputations and future workflows matter, you know, do you think it's given enough credence? Do you think people appreciate the value of the confidentiality?
So maybe not in a kind of wider context, but a lot of the clients that I deal with are very drawn to that aspect of the process, I have to say, for all of the reasons that James says around them feeling able to kind of put things on the table that perhaps they would otherwise feel reluctant or constrained to do in a kind of non-confidential process. And I think also that my feeling is, in the kind of respect to the clients that I work for, is that they're very fearful of setting a precedent. So having a confidential process means that they can reach an appropriate arrangement in relation to a single dispute or contract without fear that that might trigger unintended consequences for other contractual relationships in other areas, and that can be really quite compelling for them.
Yeah, and of course, by contrast, I mean, adjudication is confidential, but litigation isn't. It's public. So yeah, absolutely. Thank you for that, James. On coming back to you, payment rows dominate construct disputes. It's so much about money. Why would you say mediation is the smartest way forward to resolve construction money disputes?
Well, I mean, I think for the reasons we've said there, I think if it allows for creativity, I think that there's safe space, confidentiality, and without prejudice dialogue. But I think that one of the big factors is actually it allows the parties to feel like they're in control. Yeah. Whereas ultimately, when we end up in a situation where there is a decision maker that isn't the parties, then that they are, you know, they're out of control. That there's going to be a winner, there's going to be a loser. Now, I think that when the parties are invested in the process, they're invested in the project, it follows that they want to feel as if they have a final say on what they are prepared to pay, prepared to accept. So I think that has a big is a big factor in it, and I think also the speed. You know, if the parties are willing, then it can be arranged and dealt with. Mediation can be arranged and dealt with really relatively quickly. So there's that, which is a big factor as well.
And cost, a huge cost differential.
Cost is a huge factor. Yeah, of course.
Yeah, I mean, I think you alluded to earlier about adjudication you're involved in, and it costs, huge sums of money.
Yeah.
Obviously, legal costs are not recoverable in adjudication, and the party who loses generally pays the adjudicator's fee or a proportion thereof.
Yeah.
I mean, I from my experience, if you've got I would say an adjudication that's north of £100,000 in dispute, you could easily be looking at sort of £20,000+ in legal costs and £10,000 to £15,000 in adjudicators' costs.
Yeah, easily,
so even if you win, you're already down 20,000 because you never get that back, and if you lose, you're potentially down the sum claimed, the legal fees, and the adjudicators' fees. Contrast that with a day's mediation, which for a specialist mediator, with some prep and perhaps pre-meets, £4,000-5,000, it's an absolute win. So thank you. Just coming back to you, Rachel, just more of a technical question. We've seen quite a lot of smash and grab adjudications over the years, which the attempt at a quick win on a technicality. And now with recent changes in the law, with the true value adjudications, following on fairly quickly after a smash and grab, maybe to neutralize it. Do you see that change in the law as likely to lead to more mediations or encourage people to mediate more often because of the many benefits that it has to offer, notwithstanding potentially 2 adjudications back to back and doubling of the costs?
Yeah, I do. I think, as you've just referenced, it's no longer about being right on a technicality, and that immediately moves you into the territory of mediation being a very good fit to resolve the underlying issue, because mediation is all about looking at it in a wider context. So I think that I can see that parties would be more amenable to a mediation because it's about getting under the skin of the issue, and also for the reasons that we've already discussed around it going kind of to the heart of the viability of the project or the contract, because it's no longer about whether you can get one over on that technical point. It's actually about talking about the substance of the issue at hand. So I can see mediation being a very effective way of kind of dealing with that, as opposed to, minor disputes on technicalities all leading up to a kind of, for want of a better phrase, bun fight at the kind of final account stage. So absolutely, I think that lends itself, that shift lends itself very well to mediation.
And you say about bun fights and getting one over on the other side. Just to supplement, do you think there's quite a lot of ego in construction dispute resolution?
Yes. That's the short answer to that.
Yeah. Okay.
I'll say no more.
Yeah, fair enough. Great, thank you. And James, talking about adjudication, sort of parties bouncing around from one adjudication to another. I know there was with, I think, the Wembley Stadium, there was, I think, 5 or 6 adjudications launched on Christmas Eve. Following the completion of the Wembley Stadium, bouncing from adjudication to adjudication with all the time and effort. I mean, from your point of view, it just seems mediation offers an escape from that cycle. I mean, it's hugely disruptive to adjudicate, notwithstanding the cost that we mentioned earlier, but the disruption to the business and pulling people off their day jobs to find documents, to support evidence. What's your view on that, about bouncing out of adjudication?
I would agree with everything you've said there, Stuart. It can be exhausting because there's a huge amount of work, not only the costs as you say, but the management time of the businesses, the distraction that that cycle of one to the next can undoubtedly create. So I think mediation is a very simple, easy, cost-effective, quick way of avoiding all of that, and there's no reason in my mind why, just like there can be on a big construction project, as you say, the Wembley type size, where it's reasonable to expect that in the lifetime of that project there will be fallouts over payments, over time, over quality. That's all to be expected, but there's no reason why those can't be nipped in the bud on with a mediation at the very quickly, and really, I think in my experience, if I think Rachel touched on this at the start, if these issues can be captured and resolved early, it often really stops them then extrapolating into really big fallouts, because obviously the impact of one fallout can be a second fallout, third, fourth, particularly where there's a contractual chain with various parties involved. So I think getting hold of it early, quickly, cost effectively is a no-brainer.
Yeah, well, that's great. And coming back to you, Rachel, so picking up on what James has just said there, when you've got an industry, construction industry, that's so focused on cost, efficiency, timing, why isn't mediation the go-to more? Because I don't see enough mediations coming through from construction. I think people tend to default to other forms of dispute resolution. And, from the questions and answers we've had today, it would be crazy not to mediate. Why do you think people in construction simply don't do it enough?
I think there's a number of reasons for that. I think one is that when adjudication came into place, it's obviously offered up as the salve to these issues. It was meant to be a quick and cost-effective means, and as we've already touched upon, it's kind of morphed into something that it was never intended to be, I don't think. I think also that it is a fairly ego-driven litigious industry, and that drives a certain behaviour and a certain approach to resolving disputes. And I also think for the kind of reason I gave at the start, which is that there is this myth that somehow it won't resolve and you'll end up having to go through one of those other processes in any event. So I think it's kind of there's a number of sort of issues going on there, and I think there'll need to be more of a push and a focus from all of those involved, lawyers, contractors, courts, etc., to kind of, I think, put mediation more front and centre. That would be my view. And
I mean, the statistics just don't lie. 80 to 90% cases referred to mediation settled within a day. And the many fringe benefits of relationship preservation, narrowing issues, building more trust. Absolutely. So quick fire one for you, Rachel, to follow up. One thing lawyers should stop doing in mediation.
Stop treating it like adjudication or litigation, I suppose, would be my answer to that.
Yeah.
I think trying to adopt that more commercial overarching view, which, and I include myself in this, as lawyers, we can sometimes find that tricky. We're so used to, as part of our day-to-day jobs, focusing in on getting the right answer, protecting our client's position, but you have to kind of sit above that as part of a mediation process. Those things are absolutely important to build up the picture and get you to that place, but it's a layer of commerciality that I think is required.
Yeah. And following on from that, Rachel, construction disputes, what you say, they can be quite technical, delay claims, scope of contract, what's in and what's out, money, etc., etc. Do you think that having technical expertise as the mediator is that invaluable?
I do. I kind of oscillate between feeling, because as I said, people and personalities is a significant part of this, and I don't think that should be sort of undersold, as it were. And I think being a good mediator is about being able to read a room. But from a construction dispute perspective, I think a lot of the ability to kind of build trust is about demonstrating that knowledge, and also to be able to really get under the skin of a dispute. I think you do need to understand those technical aspects from a construction perspective. Yeah, absolutely. I totally agree. And in fact, that sort of answers the next question, James, which is, how important is credibility? What do you say about that?
Yeah, I would agree. I think it to a certain extent, I think it can depend on the phases of the mediation stage as well, as Rachel's alluded to. I think it's very important at the early stage to for the purposes of building trust with the parties, that the parties understands that actually you can understand what's going on from their side of the dispute. You understand the issues. and have a grasp of that level of detail. I think that is important in building trust, in building rapport. I also think it's important, actually, that if those parties are legally represented in that mediation, that the lawyers have an understanding that you are aware of the issues, so that you can, where needed, keep the lawyers in check, because they're not there to advocate their client's position. They're there to try and help negotiate a deal. So I do think that that's important in credibility. But as Rachel says, I think as the process goes on, that the biggest skill in a good mediator is being able to read the room, just read where people are, and ultimately help facilitate that flow of information, discussions and dialogue, which is very much a skill of, I suppose, emotional intelligence and human intelligence, as well as the technical knowledge. So I think it's the full package. Yeah.
Okay, great. Just conscious of the time, I'm going to sort of jump on a little bit. So just running down the list, Rachel, if the industry genuinely wants quicker, cheaper and better outcomes, what do you think needs to change to push people more towards mediation? How are we going to affect this change?
Yeah, so I think, as I just mentioned, I think it's that as lawyers, the judiciary, the industry bodies, I think there needs to be a refocusing on this and sort of putting it at the forefront. And I think obviously the Churchill judgment, the DKH limited decision last year, all of that is sort of moving mediation into that formal fitting, the changing of the CPR. It's all moving it in that right direction, and essentially putting it in a position where mediation is no longer the afterthought. It's a necessary part of the process. And I know there's lots of discussion and commentary about whether it should be mandatory or not, and the benefits and otherwise of doing that. But I think there's got to be a push amongst all of us involved in this industry to kind of put it at the forefront, and it will take everybody involved to do that.
Okay, brilliant. And the final question, James, to you. If you had one message for the construction sector about mediation, what would that be?
I think it would be to embrace it, be proactive in pursuing it, be creative with it once you're there, and be prepared to be flexible with it.
Brilliant. Thank you very much. I think that should probably wrap it up now. So thank you both to you, Rachel, and to you, James, for your insight. I think what's clear is that construction mediation really does need to grow. There's huge benefits to be had: cost, time, stress, relationships, etc., etc. And I would just say to anybody, if you do need a mediator in the construction sphere, you can see with Rachel and James, we've got two experts. Be delighted to help you, and do get in touch with us at mediatorlocator.com. Thank you very much, and goodbye for now.
Thank you.